That would hinder your instruction.
So my lords and my ladies...
5 parts. Sorry,
Five parts. The first part is to
everybody,
look at the upper...
myself. Yes.
look at the upper tribunal's order and clarify which aspects are under challenge in our appeal and in the respondent's notice.
Yes.
The second part is to go through the relevant statutory law and immigration rules.
Yep.
The third part is to examine the upper tribunal's decision. The fourth part is to go through the different grounds of appeal that we have brought. And I hope I will have covered much of that when I was going through the second and third parts. And then the final part will be a brief response to the points in the respondent's notice and the respondent's skeleton. So if I begin with the order under appeal, the first part of my submissions, that order is at page 88 of the call bundle. If you have that, you can see that the order itself refers to ground 1 and ground 2. That's a reference to the 2 grounds of judicial review that the claimant had brought. Ground 1 was that the Secretary of State was obliged to grant leave to remain, either A, under the common law, or B, by reason of Article 8. And ground 2 was that the Secretary of State erred in refusing the statelessness application. That's to say, the application under the immigration rules relating to statelessness. And we appeal against paragraphs 1, 4, and 5 of this order. One and 4 go together. 4 is a declaration to reflect AM success on ground 1, and we say that AM should not have succeeded on either limb of ground 1, and if he had failed on ground 1, he wouldn't have obtained any declaration. We also say that even if AM was entitled to succeed under ground 1, he should not have obtained the declaration that he did at paragraph 4. For reasons I will come to, the failure to grant leave to remain was not an interference with AM's Article 8 rights at all, let alone a disproportionate one. This was, at best, a positive obligation case, not an interference case.
So even if your case is if entitled to succeed under ground 1, not entitled to the declaration.
Yes.
What do you say? Just no remedy at all?
Well, no. If they were right under that there was a breach of Article 8, it should have been there is a duty to grant leave to remain, rather than continuing to refuse as a disproportionate interference.
Sorry, wait a minute, hold on. So that you say if AM succeeded under ground 1, the remedy was...
a different form of declaration.
Have you formulated that anywhere?
We haven't, no.
Right, can you give it to us?
Yes. it is declared that there is a positive obligation under Article 8 ECHR to grant the applicant leave to remain in the United Kingdom. That's not the main focus of the case, as you'll understand.
Yes.
But it is
But that's to reflect your case as to the difference between interference and positive obligation.
Yes. If that's all I win on, then I won't have succeeded with the main purpose of this appeal. The order at 5, paragraph 5, stands or falls with AM's success on ground 1. And we say that you should set aside paragraphs 1, 4, and 5 and make a new order simply rejecting ground 1. AM, by his respondent's notice, appeals against paragraph 3. He appeals against the refusal, the dismissal of the ground that relates to the statelessness application. As I understand it. Is that wrong?
Sorry. My understanding is we don't appeal against that part of the order. We have filed a respondent's notice which says that ground 1 should be upheld for
different reasons
that the upper tribunal rejected.
Well, I'm very grateful for that clarification. I apologise for getting that wrong. So their case is ground 1, but possibly by a different route.
So it's a respondent's notice to affirm rather than to cross appeal.
Right, so.
So that's the first part of my submissions, looking at the order. If I can now take you to the statutory framework and the immigration rules. They're in the main authorities bundle, behind the first 2 tabs of that. And we'll start with tab 1. And if you turn, please, to page 4 of tab 1, you'll see the beginning of sections 117A to D of the Nationality, Immigration and Asylum Act 2002. Just an outline, what these provisions do is that they tell tribunals and courts how to approach Article 8 in deportation and removal cases. In essence, Parliament was concerned about inconsistent and at times overly generous decision-making by immigration tribunals in Article 8 cases. So Parliament made statutory provision laying down how tribunals should approach Article 8 cases. And you can see that if you look at section 117A, subsections 1 to 2. This part applies where a court or tribunal is required to determine whether a decision made under the Immigration Acts breaches a person's right to respectful private and family life under Article 8 and as a result would be unlawful. And then subsection 2 sets out that in considering the public interest question, the court or tribunal must, mandatory obligation, in particular have regard, A, in all cases, to the considerations listed in section 117B, B, in cases concerning the deportation of foreign criminals, to the considerations listed in section 117C. And then subsection 3 defines what the public interest question is there. Now, what we have here is a reference to considerations in 117B that apply in all cases, and then 117C just for foreign criminals. In our case, we're dealing with a foreign criminal, so it's both 117B and 117C.
Can you just say what decision is made under the, which was the subject of the challenge in the judicial review? Was that made under the Immigration Acts and what section?
Well, the decision to refuse leave to remain under the statelessness application and the decision not to grant leave to remain are both decisions under, I think from memory, it's section 3 of the Immigration Act 1971, which...
Well, that gives the power to grant, yeah.
Yes.
Thank you.
So if one looks at 117B, these are the public interest considerations applicable in all cases. There are two subsections of this that are of particular importance. The first, of course, is that the maintenance of effective immigration controls is in the public interest. That's subsection 1. The second, which is really critical to this case, and the upper tribunal didn't properly or at all grapple with, is subsection 4A. Little weight should be given to a private life, skip a few words, that is established by a person, should be person of course, at a time when the person is in the United Kingdom unlawfully. So bear in mind, in our case, all of AM's residence in the UK has been unlawful. And his case was all about private life. And here is Parliament saying that little weight should be given to a private life established in those circumstances. The point of this provision is that anyone who doesn't meet the requirements of the immigration rules, but says instead, you should grant me leave to remain outside the rules because of Article 8 and my private life, is going to find it very difficult to succeed if their time in the UK has been unlawful. And that principle holds true in any immigration case. The bar in a foreign criminal case is even higher, as we'll see if we turn to page 8 and section 117C. So section 117C1 says that the deportation of foreign criminals is in the public interest. That's a mandatory consideration in every case. And then subsection 3, in the case of a foreign criminal who has not been sentenced to a period of imprisonment of 4 years or more, the public interest requires ceased deportation unless exception 1 or exception 2 applies. Pausing there, that's the category of foreign criminal that AM is. None of his sentences were 4 years or more, so he falls within this. Exception 1 is the exception that deals with private life, and you can see that there are 3 necessary conditions for success on exception 1. The first is that the claimant has been lawfully resident in the United Kingdom for most of the claimant's life, and AM failed on that criterion. The second is that they're socially and culturally integrated in the United Kingdom. AM also failed on that, and there's a finding of the upper tribunal to that effect that I'll come to. The upper tribunal never had to look at the third criterion, because AM comfortably failed on both A and B. Now, I don't say that that is determinative, because the Court of Appeal in a case called NA accepted that there can be circumstances where a private life claim may succeed, even though exception 1 and exception 2 are not met, and they're very, very compelling circumstances. But it's worth noting that AM was not even within what you might call a country mile of satisfying exception 1. So then I turn to the immigration rules. There are two sections in the immigration rules which are particularly relevant to this case. Each provides a route whereby someone who's been in the UK unlawfully may nonetheless be able to obtain leave to remain. The first of these sections begins at page 14, and it's headed Private Life. You can see it about halfway down the page on page 14. It's 276 ADE. And what this rule does is that it enables certain illegal migrants who have lived in the UK unlawfully for a long time, but who have avoided certain kinds of prescribed behaviours to regularize their status. So if one was thinking about how this fits with section 117B3A, little weight to private life when living in the UK unlawfully, well, this rule is more generous than that. It's more generous to unlawful migrants than Article 8 or section 117B3A requires, because it allows someone who's been living unlawfully in the UK for a long time to obtain leave to remain if, I stress if, they avoid certain prescribed behaviours. And that's why it's more generous. It's to incentivise good behaviour and compliance. So there are three conditions for success under section 267 ADE. The first, which I'll pick up in a moment, is does not fall for refusal under any of the grounds in section SLTR 1.1 to SLTR 2.2 and SLTR 3.1 to SLTR 4.5 in Appendix FM. And I'll take you to that in a moment. That's the first condition. The second condition is has made a valid application for leave to remain on the grounds of private life in the UK. And then there's a third condition, which is to meet one of subsections 3 to 6. You see, those four subsections are all in the alternative with ors in between them. And what those subsections do, subsections 3 to 6, they focus on either the length of residence or the obstacles to return. And there are different tests depending on how old the person is. In our case, AM was over 25, so he had to meet either condition 3, 20 years lawful residence discounting any period of imprisonment, or condition 6, which is very significant obstacles to integration into the country to which you would have to go. Now, you'll see that the phrase discounting any period of imprisonment appears in each of these subsections, 3 to 6. And that reflects the fact that in Article 8 case law, there are certain kinds of lifestyle that don't attract the protections of Article 8 and the respect for private life. And that's why time in prison shouldn't count towards private life in the UK. Now, of course, success on these, one of these conditions, 3 to 6, is not enough. And as I explained, one needs to pass that very first hurdle of 1. And 1 is particularly important to our case. The refusal grounds mentioned in 1 appear later behind the same tab at page 18. That's section S LTR. So you can see that these refusal grounds, if you read through all of them, and I'll take you to some of the most important ones in a moment, but if you, just setting the picture, if you read through all of them, you can see they're not limited to criminal offending of the kind that AM engaged with. They cover many kinds of non-compliant behaviour. And when you combine these rules with 276 ADE, what you have is an incentive for good behaviour and compliance. If an illegal migrant staying in the UK for a long time avoids the kinds of prescribed behaviours set out here, they can obtain leave to remain after 20 years. By contrast, if they don't, if they engage in the prescribed behaviours, then it will be much harder for them to obtain leave to remain. They will need to rely on Article 8 and go outside the rules, and they will face the difficulty of Section 117B3A, sorry, 4A, and the fact that little weight will be given to their private life, as it was built up when they were here unlawfully. So, going through 1.1 to 1.8, those are the mandatory grounds for refusal, and 1.2 to 1.6 relates to criminality. 1.7 relates to non-compliance with administrative processes. In other words, not cooperating with the process for removal. AM fails on several of these mandatory grounds. 1.2, he is the subject of a deportation order. And that order was served on 24th of May 2001, over 20 years ago, still extant. 1.4, he fails on this ground too, because his presence is not conducive to the public good, because he's been convicted of an offence of less than 4 years and at least 12 months. 1.6, if it were necessary, the Secretary of State could also have relied on this. His character and associations do not make his presence conducive to the public good. 1.7, he'd also fail on this ground, because he has failed without reasonable excuse to comply with requirements to provide accurate biodata that would have enabled removal to Belarusian to take place. So, properly analysed, this was not a near-miss case at all. AM was very far from the kind of person these rules were intended to reward. The point, just focusing on 1.7, the purpose of 1.7 is to give a powerful incentive. When you combine it with 276 AD, it gives a powerful incentive to an illegal migrant to attend interviews and provide the information that they have been asked to provide.
You've said he failed to provide physical data. There's some suggestion in some of the other skeletons that he has provided information. So in order to avoid us having in the small hours to work through the whole bundles and work out when, So can you give us chapter and verse about when he failed to do that? Because it's not in a decision letter itself, is it?
It may not be in a decision letter, and I will endeavour to give you chapter and verse on that. I hope after the short adjournment.
The deportation order, I understand. The offending, I understand, is there. The failing to provide physical data, I think you'll have to make good. Perhaps you can, perhaps you can't, I don't know. But we need that information rather than just an assertion.
I quite understand. Yes, I will attempt to make that good later, if I may, with the help of Moylan Junior. It doesn't really affect, though, whether or not he actually falls within 1.7, doesn't affect the sort of principle that I'm trying to clarify, which is that the purpose of these rules combined with 276 ADE is to say to, let's say, an illegal entrant who is asked to attend an interview and provide information, they have an incentive to do so, because they know if they do that, they will stay on the right side of the suitability requirements and potentially be able to obtain leave to remain under 276 ADE. If they don't, then they have the penalty of falling outside the rules and having to instead rely on Article 8 and facing all the difficulties of 117B4A. 2.1 to 2.5 are grounds where leave to remain is normally refused. And it includes things like providing false information, representation, or documents in support of an application. 4.1 and following are discretionary grounds of refusal, and they cover historic representations, non-disclosures, and failure to pay bills. And so, again, the purpose is to incentivize compliance. Illegal entrants, unlawful migrants who behave honestly with the UK authorities, disclose material facts, answer questions truthfully, pay their NHS bills, they have the reward of potentially being able to obtain leave to remain under 276 ADE when they've been in the UK long enough, or it comes to a point where they can't return. But those like AM, comes to a point where there are significant obstacles to reintegration, I should say. Those like AM, who are dishonest in their dealings with the Home Office, have the penalty of having to go to Article 8 outside the rules, where unlawful private life is to be given little weight. We don't, in light of my learned friend's helpful clarification, we don't need to go over the rules on statelessness. There is just one other aspect of the immigration rules that I'd take you to, which is the rules relating to foreign criminals, and that's at 20A. You can see, if you look at 20A, A398, these rules apply where, and then the second, there's A and a B. The B is a foreign criminal applies for a deportation order made against him to be revoked. And that's in effect what this applicant, this is what AM has done, because to get leave to remain, you need the deportation order to be revoked. And so, in those circumstances, you then have the rules at 398 and following, which mirror 117C of the 2002 Act. Our case falls within 398B. The deportation of the person from the UK is conducive to the public good and in the public interest because they've been convicted of an offence for which they've been sentenced to a period of imprisonment of less than 4 years, but at least 12 months. And so what the Secretary of State needs to do, looking at the end of 398, is assess whether paragraph 399 or 399A applies, and if it does not, the public interest in deportation will only be outweighed by other factors when there are very compelling circumstances, over and above those described in paragraphs 399 and 399A. And of course, in assessing whether things are very compelling circumstances, one should have regard to the mandatory considerations in section 117A to D. And just to conclude, if you go over the page to 20B, you can see that the exception in the rules relating to private life mirrors the exception in the statute relating to private life. And it has those first two conditions, lawfully resident for most of life and socially and culturally integrated in the UK. Those are ones that AM failed on. So that's the second part of my submissions.
Does 399B have any relevance?
No, I think 399B deals with the sort of mechanics of when a claim is successful, rather than actually setting out when it should be successful.
I understand that.
So that's what should happen if the order below is upheld.
That would, yes, I think that would govern what will happen if the order below is upheld, yes.
Or your alternative order.
Yes.
Forgive me for getting to my feet. I had not understood that the upper tribunal's order was any form of bar to deportation. It's not an order in respect of a challenge to a deportation decision.
Right.
It's only an order which goes so far as to say that if and so far as he has to remain here, Article 8 requires him to be granted some form of regularisation to be left open to the Secretary of State.
I see. You say this section doesn't apply at all because it's dealing with deportation.
Yes.
Yeah.
There's no bar to deportation as a result of the order of the upper tribunal.
Which I think, Mr. Dunlop, if that's right, that narrows then the scope of your challenge and indeed some of your expressed concerns in writing, which is, if I have to stay here, I mean, the original claim in 2011 simply said, just let me work. The claim then expanded to include statelessness, which has failed and stays failing, but then got reworded. But if that is right, then that explains why there was no order by the upper tribunal quashing the deportation order made in 2001.
I'll need to think and take instructions and look this up, but it seemed, I'm not sure that it's right, that if someone is granted leave to remain, I'm not sure if someone can be granted leave to remain with an extant deportation order.
My understanding, forgive me, and I'm sure that your client will give the definitive answer, but my understanding is that the grant of leave invalidates an extant deportation order. So that order couldn't be acted on in respect of a person who's been granted leave. I might need to check whether that applies only to indefinite leave to remain, but I think it applies to all grants of leave to remain, invalidating extant deportation orders. However, there's nothing in the upper tribunal's order or in their conclusions which prevent a further order being made. I'll ask my junior to look up the section of the Immigration Act.
Looks like both of you might be asking your juniors to.
Quite a lot, yes. So I think it's common ground between us that if the order of the upper tribunal were complied with and the Secretary of State were to grant leave to remain, the deportation order that is currently extant would cease to be extant. I think my own friend's point is, well, the Secretary of State could then at some point in the future make another deportation order.
Yes, that's what Ms. Weston was proposing or submitting, subject to clarifying that that is indeed applicable in respect of limited leave to remain.
Yes.
So I think we need confirmation as to what the effect on the existing deportation order would be of the grant of limited leave to remain.
Yes.
And Mr. Dunlop, just so that you know, whatever the position in relation to that, it would be helpful to have submissions directed to this point. Article 8, assuming it's engaged either negatively or positively, might engage issues such as the right to work. At the moment, this applicant doesn't have the right to work, is that right?
Correct.
At the moment, he's not going to go anywhere. That means that you're creating almost a perverse incentive to create an economy which is unregistered when you know he can't go and has no status to work.
Well, I don't accept that he can't go. He can go if he chooses to cooperate.
I understand that, but he hasn't cooperated for 20 years, and that was the point. At the moment, your submissions are directed to leave to remain, treat him as if he has on the journey to indefinite leave to remain, which may be very different from what the tribunal or upper tribunal contemplated, which was some statelessness, some position other than the harsh environment, where you can't get rid of him.
Yes, I didn't mean my submissions to be focused on a path to settlement or indefinite leave to remain. My point is, and one of the reasons I took you through 276 ADE, is that the upper tribunal misunderstood the rationale of 276 ADE and thought 20 years of unlawful residence was a sort of yardstick for Article 8 purposes. It's not a yardstick, and actually properly analysed, their order was inconsistent with the rationale. The rationale is to be more generous than Article 8 requires in order to incentivise good behaviour.
But that still leaves the position of those who haven't behaved well, who will not get the benefit of that, who can't be removed within a reasonable time and where the prospects are remote in various degrees. What is the position for those persons? And just so that you're aware, I mean, you're probably aware also of the current figures for outstanding asylum applications, the current regime in which applies to all those people waiting there under the harsh regime with no ability to work, where effectively, when you're making complaints about what the courts are looking at in terms of these matters, you're looking at a situation where you end up creating a situation where the opposite of what the Secretary of State is intending is happening, which is people are working without declaring any tax at all.
Well, with respect, my Lord, I understand that as a sort of policy argument, but the immigration rules set out how the Secretary of State has decided to deal with those policy issues. And the flip side of the coin, which 276 ADE is designed to address, if you like, is that without the sort of incentive of clearly demarcating those illegal entrants who can get leave to remain and those who can't, then there may be many more people who are prepared to overstay for long periods of time or to refuse to comply with the mechanics of removal or to commit criminal offences. That's how there might be different conclusions that an executive could reach on the issues that you raised, but that's how the executive has decided to strike the balance with these rules.
Now, I entirely understand that, and policy is for the executive subject to the legislature in these respects. But there are bits between the leave to remain and a person who's simply here for a very long period of time without in the harsh environment. And that may engage Article 8, albeit on a completely different basis from this, which contemplates a journey to indefinite leave to remain and then status.
Yes. I mean, of course, there are different factual scenarios we don't have to deal with. In our case, perhaps the key fact is that it lies in the control of AM how long he stays in the UK. He can, and this is the findings of all the tribunals and the Court of Appeal last time, he can change things around, cooperate, tell the truth, and go back to Belarus. And if you like, the point of the hostile environment, or compliant environment as it's now called, is to put pressure on people like him who have it in their power to go home, You see what I mean?
And is the essence of that if on your case he provides the accurate details and that can be achieved, is that it?
Yes.
Well then may I say, Mr. Dunlop, I think it particularly incumbent on the Secretary of State to clarify exactly what he has produced, because as I understand the point made on behalf of AM, it is that further disclosure has taken place, which was not even before the Court of Appeal in the last proceedings. And that, taking up the point made by my Lord Justice Dingemans, is important because, speaking for myself, the allegations and counter-allegations as to what has been disclosed, what is accurate, what isn't accurate, isn't clear in this in the many papers.
Yes. Well, I'm grateful for that indication. I mean, so to understand, our position, like the upper tribunal, is that firstly, none of that new disclosure makes any material difference to the findings that have been made by previous tribunals and the Court of Appeal. And secondly, there was no wrongdoing, if it be suggested, in those interview notes not having been disclosed before. There is no duty in statutory appeals to disclose such notes. They are available, however. For example, if someone makes a subject access request, and that's what the upper tribunal said, they were available to the previous representatives at all times. Can I then turn to the third section of my submissions, the decision under challenge. It begins at page 90 of the core bundle, and it's behind tab 9 if your core bundle is tabbed. Paragraphs 1 to 63 are essentially a recital of the facts, and I don't intend to go over all those facts. We'll just highlight 9 points, if I may, which I'll take in chronological order, which is not necessarily the same order as they're set out in the upper tribunal's decision. So, fact 1, which is in paragraph 2, AM is a citizen of Belarus. Fact 2, he first claimed asylum in the UK in January 1998, 24 years ago, using the name that we have in these proceedings. Fact 3, within a year or two of his arrival, he committed a serious offence of violence And in 1999, he began a sentence of 3.5 years for actual bodily harm and unlawful imprisonment. He has subsequently committed later offences, possessing a false document and an offensive weapon.
Do we have his criminal records checked? Because there are different ways in which his criminal record had been summarised, and it would just be helpful to have it all in one place.
I don't think we do. I apologise for that.
No, don't worry. But I mean, perhaps we could just actually have an agreed record of
Yes.
the position.
Well, the one I think that the paragraphs of the upper tribunal's decision that set out their findings are paragraphs 16 and 43,
Right.
and I don't understand those to be disputed, but my learned friend will no doubt correct me if they are.
But, well, one of the reasons for asking the question is if you look at paragraph 43, it says he was sentenced to 42 weeks imprisonment for possession of an offensive weapon, 26 weeks for the offence, together with activation of a suspended sentence within 16 weeks, which tells you, if you've done any criminal law, that he must have been sentenced for something else within 2 years before that. But try and find that, and it's difficult.
I understand. We'll attempt to.
That would be very helpful, thank you.
Fact 4, he was actually deported to Belarus, but he successfully managed to get himself returned by telling Belarusian authorities he was not from Belarus. And that's paragraphs 3 and 8. Later, he repeated that lie to the Belarusian authorities when attending their embassy in the UK. That's paragraph 13. Fact 5, he has provided forged documents to support asylum claims. For example, the factory ID of a company which did not exist. Fact 6, he's had 3 appeal hearings, each of which were unsuccessful. There were adverse credibility findings. And in the last, Judge Pula found the likely reason that Belarus authorities wouldn't take him back was he failed to provide accurate information to them.
Can I just ask another question on the facts while you're going through those?
Yes.
The materials show that he has his father deceased in 92. He last had contact, it said, in 97 with his mother and brother. Are there findings that he does have a mother and brother? And if so, what has been done about finding them? Because we see that the British Embassy has trogged around and looked at various schools, various factories, various rivers, but nothing about the family.
I don't know off the top of my head. I'm hoping.
Perhaps you can check.
Yes, that will be added to the list.
Sorry to ask so many questions.
Yes, no, but of course, my lord. So fact 7 is that he has hepatitis C and psoriasis. Fact A is that he is a Class A drug user. And fact 9 is that he applied for leave to remain as a stateless person, but this was refused as he didn't meet the criteria, as he was a national of Belarus under their law. So if I then move on within the decision, the upper tribunal's decision, to paragraph 64, page 102 of the call bundle. That's paragraph 64 there sets out the 2 grounds that were being considered, and as I explained at the outset, ground 1 was a challenge to the ongoing refusal to grant leave to remain. Ground 2 was a challenge to the decision on the statelessness application. Now, ground 1 had 2 limbs. The first limb was under the common law, and the second limb was under Article 8. And paragraphs 65 to 94 of the Upper Tribunal decision consider the case law on the first of those 2 ground 1 limbs, namely the arguments that common law required a grant of leave. And the argument was, in essence, that as AM couldn't be removed, there was no power to keep him on temporary admission or bail, and the common law therefore required a grant of leave to remain. Paragraphs 65 to 90 analyse the House of Lords judgment in Kadir and the Court of Appeal's judgment in MS, which are the 2 leading authorities on the scope of the old statutory power to grant temporary admission, which is effectively the same as the new statutory power to grant bail.
Sorry to interrupt, but so your submission is that temporary admission and immigration bail are to be equated for these purposes?
For these purposes, yes.
Right, thank you.
We don't demur from that.
No, thank you.
Paragraph 91, having set out a lot of quotations from the judgments in MS, paragraph 91 distills down those judgments, and it's a correct summary of those judgments, which we agree with. The point is made, in essence, that each of the 3 members of the Court of Appeal in MS put the test in terms of impossibility. Put it another way around, there is a power to grant temporary admission, or these days bail, unless removal is impossible. Paragraphs 95 to 105 go through the case law on the second of the ground 1 limbs, the Article 8 case law. Paragraphs 98 to 100 cite 3 authorities, SH, Abdullah and AB, where the Court of Appeal rejected arguments that Article 8 required the Secretary of State to end the applicant's limbo and grant leave to remain. Paragraph 101 refers to a case called Mendizabal that we will come back to. It's a Strasbourg authority where Article 8 was found to require or to impose a positive obligation to grant leave to remain. But that critically was a case involving someone who is living lawfully in the state, but on short residence permits. So it's a very different kind of case to ours. Paragraph 102 is a quotation from Lord Justice Haddon Kaye's judgment in RA, where he says how striking it is that no one's ever succeeded on a sort of limbo Article 8 case. Paragraph 60 about 3 lines down, he says, it's striking the only known example of a limbo argument being successful is in the Strasbourg case of Mendizabal, which involves 2 singular features, an exceptionally lengthy period of limbo, namely 14 years, and no question of the claimant being returned to Spain. As we'll come on to, that those are not the only 2 distinguishing features. Mendizabal was in France lawfully the whole time and had a right under EU law to permanent residency. He was also in France for a lot longer than 14 years. So then paragraph 103 is a quotation from RA again, which sets out the 4-stage analysis Lord Justice Haddon Cave referred to. So there's stage 1, which is distinguishing between prospective limbo and actual limbo. And pausing there, there's no dispute that our case is about actual limbo. Stage 2 is the sort of threshold test that the prospects of effecting deportation must be remote, and that's analysed later in the decision what that means. They conclude it's not the same as Kadir impossibility, and we agree. Stage 3 is the fact-specific analysis, and we would highlight of particular importance in this case is Roman 5, whether the impossibility of achieving deportation is due in part to the conduct of the individual. And then stage 4 is the balancing exercise, and we say that the upper tribunal misdirected themselves when conducting this balancing exercise and failed to take into account material factors, misunderstood the rationale, for example, of 276 ADE.
Can I just ask whether you accept that which was left open in MS but is implicitly answered in RA is common ground, which is that Article 8 can provide a route to the grant of leave?
I think theoretically there might be such a case, yes.
Because it was also suggested by Mrs. Justice Simler in Hamza that one wouldn't, but you accept there could be a case.
Theoretically, it would certainly not be a case where the person in question has it in their hands, in their control, to bring to an end their state of limbo by returning to their country of nationality.
And from the submissions you just made, am I right in thinking that you endorse the 4-stage analysis undertaken by Lord Justice Haddon Cave, and you just say that the upper tribunal went wrong in their application of it?
Yes.
And you're focusing on the balancing exercise?
Yes. I might add, I don't demur, I don't sort of differ from RA, I don't say it's wrong, but there are things that I might add to it, such as the importance of considering section 117b(4a) and grappling with that. Parliament has especially required tribunals and courts to do that.
Sorry, grappling with what?
The principle in 117b(4a) that little weight is to be given to a private life established when someone is in the UK unlawfully. Paragraphs 104 to 105. This is the upper tribunal's analysis of what stage 2 in RA meant. They point out that there are 2 possible interpretations of stage 2. It could either require removal to be impossible, like in Hadir, or it could set a lower test. And the upper tribunal chooses the latter, the lower test. And paraphrasing their reasoning at paragraph 105, what they essentially are saying is stage 2 is meant to lay down a necessary but not sufficient condition for obtaining leave to remain. If removal is actually impossible, at any stage meets the Kadir test, that's a sufficient condition for obtaining leave to remain. So, concludes the upper tribunal, stage 2 must set a lower threshold than impossibility. And we accept that analysis. And we accept that the lower threshold is met in this case. Removal in this case is removed.
So the focus of your submissions is stage 4, the balancing exercise.
Yes. Paragraph 107, this is where the upper tribunal applies their conclusions on the law to the facts. And what they do here is apply the orthodox, and we say correct, interpretation of Kadir and MS to the facts and to ask, is removal impossible in this case? And ultimately they conclude that removal is not impossible, and we agree with that. I'll just highlight some of the reasoning for that conclusion. Paragraph 114. The upper tribunal makes the powerful point that it does not lie in the mouth of someone who refuses to disclose their true identity to say removal is impossible, because it lies within their power to change that state of affairs. Paragraph 115 makes an exception to that, which I think is a fair exception. If a person has become so mentally ill as to be permanently incapable of recollecting who they are. But they make the point that the evidence does not disclose such a state of affairs in this case. Although he has medical issues, they're not of such severity to render him incapable of exercising free will or discerning the difference between truth and falsehood, or to have irrevocably destroyed his memory. So in answer to my Lord Justice Dingemans' question, I can see that if someone was irremovable because they'd lost the capacity to provide the information needed to obtain a document, that's the kind of case where I can see that after some time Article 8 might require a grant of leave to remain. I don't say it always would, I accept that there's just a possibility in a case like that, but that's not our kind of case.
Well, you would also, no doubt, be engaging Article 3 issues if you try to return someone who lacked capacity.
That might or might not be right. Even under Paposhvili, the test is pretty high for Article 3. And if it's returning them to a country where the treatment for people who lack capacity wouldn't expose them to a substantial risk of some adverse effects or substantially shorten their life, then I'm not sure Article 3 would have anything to add. They then say at paragraph 116, we do not accept that the applicant has been candid in the past about sufficient aspects of his personal information so as to enable the respondent to effect his return were the Belarusian authorities to be cooperative in this regard. So that's a finding that he has not been sufficiently candid in the past about sufficient aspects of his personal information. He hasn't provided all the information he could have done. We accept Mr. Fort's, that's Counsel for the Secretary of State below, submission that no proper basis has been shown for us to go behind the adverse findings of the two adjudicators and the first-tier tribunal judge. Although certain of the documentation, including the interview at the Dover Removal Centre, has only been adduced relatively recently in the course of current proceedings, the relevant interview records relied on were supplied to the applicant's previous advisors or were otherwise available to them. And I made that point about what level of disclosure is required and what means are available to obtain interview records if they are thought to be relevant. And then in paragraph 117, they make another important finding. So far as concerns the submission that the Belarusian authorities would not readmit the applicant even if he told the truth, the Court of Appeal, at paragraph 43 of AM Belarus 2014, specifically rejected this aspect of the applicant's case on the basis that the first-tier tribunal judge decided that question against the applicant, as did Upper Tribunal Judge Southern. Again, no satisfactory case was made for us to reopen this matter. So that is a finding consistent with earlier findings that the applicant is wrong to suggest he wouldn't be admitted even if he told the truth. Put it the other way around, if he does tell the truth, he could be readmitted. Paragraph 118 to 119 are the conclusion rejecting that first limb of ground one, the common law argument. Paragraph 120 is when they begin the Article 8, the second limb of ground one, the Article 8 consideration. And they start with the first stage, and they say AM has been in actual limbo for over 20 years. We accept that, but they make at the end of this paragraph, they make a comparison that is at best inapt and at worst displays a fundamental misunderstanding of Mendizabal. They say this period far exceeds the 14 years which led the Strasbourg court to conclude that Ms. Mendizabal should have her status regularised on Article 8 grounds. We'll come back to Mendizabal, but that is a misunderstanding of the sort of facts and judgments and principles in Mendizabal, which seems to have led them to place more emphasis on these 20 years than they should have done. As I'll come on to explain, Ms. Mendizabal had in fact at the time of the judgment of Strasbourg been in the UK lawfully for 35 years. In France, lawfully for 35 years. And the problem for her was not that she didn't have lawful residence. She did. The problem for her was she was just given lawful residence for very short periods, months at a time.
3-month periods.
Yes. So it's quite a different case and really not a helpful comparison, this 14 years, to AM, who had 20 years of being in the UK unlawfully. Stage 2, the second stage, they then ask whether the prospects of removal were remote, and they make the point that the prospects are indeed remote, but they also explain why. They make a finding as to why. And that's the third sentence of paragraph 122. The prospects for removal of Belarus are indeed remote. Then it says, the fact that this is because the applicant has maintained an entrenched position will be relevant when we come to stages 3 and 4. So if one's dealing with findings of fact, then there's a finding of fact that the reasons why removal remote is because of his entrenched stance, the thing that has been discussed earlier in the judgment, the failure to tell the truth. Paragraph 123 is begins the analysis of the third stage. And in essence, they recognise that AM has no family life in the United Kingdom. He has some but minimal private life. He's committed serious criminal offences. Then, paragraph 125 they say that the time the applicant has spent in the United Kingdom is very great, probably the longest spent by anyone in immigration limbo in this country. Well, we accept that the time, 20 years, is a long time, but we don't accept it's probably the longest time ever. There wasn't any actual evidence to back up that.
On the other hand, you're talking about the president of UTIAC, who had, before he became a High Court judge, served a long period of time in the upper tribunal.
I'm sure that's right. I'm sure that, well, I am certainly talking about the president, and I'm sure that he has, well, of course he has a lot of experience about immigration law. How many cases like this he's heard, I do not know. And how many other people there are who haven't brought cases, I do not know. The last sentence of paragraph 125 seems to be at odds with, or if not sort of, or water down the earlier finding about the fact that he has capacity to tell the truth. The tribunal says, although the respondent's difficulties in this regard stem from his entrenched stance, we take into account the fact that had he been proffered to give evidence, the applicant would have fallen to be treated as a vulnerable witness owing to his physical and mental health problems. It's not clear why they take this into account, and in our submission, either he has capacity to tell the truth or he doesn't. And if he has capacity, as they found he does, then it's no excuse that he may be a vulnerable witness.
Was capacity an issue?
No.
No. So they didn't make a finding. They just didn't say one way or another. Sorry, it's just when you said which they found he did, I hadn't noticed any finding on capacity.
Well, they did in effect they say, paragraph 115, that his medical issues were not of such severity as to render him incapable of discerning the difference between truth and falsehood, or destroying his memory.
Yeah.
Well,
yeah.
perhaps I shouldn't introduce the concept of capacity. But I think the point is, if he can remember and he knows the difference between telling the truth and lying, then why does it matter if he's a vulnerable witness? The proper way of looking at it, consistently with RA, is to treat as an extremely important factor the fact that he is responsible for the remoteness of removal. And it looks very much from this last sentence that key point is being downgraded for reasons that are not sufficient or appropriate. The fact that he's a vulnerable witness.
Yes, but his vulnerability is set out to an extent in the next paragraph, isn't it? Because it was the assault in 2018, following which there are seizures, and there appear to be other problems as well. And while it might not go to a core issue of capacity, it certainly would reflect his ability to remember and to give evidence.
Well, it would reflect his ability to, it could theoretically affect that, but the findings back at paragraph 115 are that the illness and injuries are not such as to destroy his memory.
Irrevocably.
Yes.
That doesn't mean to say it isn't affected. That is destruction.
Yes.
Well, before you get to destruction, there are degrees.
Well, I accept that. There are degrees to which memory may be affected by injuries, but reading the findings together, the findings that it's because of him that removal is remote, and his memory is not irrevocably destroyed. What that means in my submission is that he, notwithstanding any injuries, has further memories that he could have been honest about, but has not been honest about. And that has caused his irremovability. Paragraph 129, there are findings on the medical evidence, and what is said here, if you pick it up with the fourth line, it's plainly unlikely that if he were to be given leave to remain, the applicant would become a model member of society. And the furthest they will go, if you look at the next sentence, is that he retains capacity for self-improvement. But of course, having capacity for self-improvement and being likely to improve are different things. And as we'll see when they come back to it, really what this amounts to is a finding that leave to remain would offer a slim possibility of improvement in AM's antisocial behaviour and lifestyle. So paragraph 130 and following is where the analysis of stage 4 begins. And you can see at paragraph 130 that the upper tribunal cites section 117C, the provision relating to foreign criminals. What they don't cite is section 117B.
Well, they do. If you look at line 4, they don't set it out in great detail, and they don't lengthen the judgment, but they actually specifically say sections 117B.
Well, they refer to it. They don't. Sorry, what I meant to say was they don't cite it. They talk about the need to have regard to the sections, but the section that they cite and focus on is 117C. I accept that there's a reference to 117B. All I meant to point out was that they don't actually cite it or expressly have regard at any point to the consideration 117B 4A about little weight being attached to a private life established when someone is in the UK unlawfully. Paragraph 132, they rightly find that AM cannot satisfy exception 1, and they make the 2 points that made before about him not having been lawfully resident and not being socially and culturally integrated. Paragraphs 135 to 136, this is where the upper tribunal looks at deterrence. And deterrence is a key issue. The Secretary of State is concerned about the effect of a grant of a leave to remain in this case on other illegal immigrants. The Secretary of State is concerned that such people will not focus on the incidental details of AM's personal life, but on the general principles to be drawn from this case. For example, the suggestion that 20 years of unlawful residence is an important yardstick. When we look at the way that the upper tribunal considers deterrence, in paragraph 136, they don't focus, as we say they should, on what illegal entrance would take away from this case. Instead, they focus on what members of the British public would think about this particular person's life. So, going through 136, it seems to us that a dispassionate member of the public, so here we have the focus being on the public, and it's spelled out later that it's the British public we're talking about, considering the applicant's history, again, a focus on his specific life rather than the sort of broader message of the case, if you like, would not conclude that the applicant has gained any real benefit from his presence in the United Kingdom over the past 2 decades and more. He's not forged any family life. On the contrary, his life has been one lived at the outer margins of society. He's been legally unable to work, except he's had periods of street homelessness. He's become addicted to drugs and alcohol. These are all the details of his life, which shouldn't necessarily apply to every illegal entrant who had stayed for a long time. They'd all be legally unable to work, but all the other details wouldn't necessarily apply to them. Although one does not, of course, know what kind of life the applicant might have led had he remained in Belarus, a hypothetical member of the British public, again focus on what the British public would think, would be likely to conclude that if the applicant did come to the United Kingdom for a better life, he's conspicuously failed in that aim. And pausing there, that's not really the question that deterrence is about. It's about what will other illegal entrants in the UK take from this. And I'll come back to that when we come back to the grounds. Then the conclusion in the last sentence, accordingly, a grant of leave to the applicant at this point is unlikely to encourage others to follow his example, thereby leading to a general weakening of the immigration system. That is a non sequitur. It's supposed to follow, hence the word accordingly, but it doesn't follow from the reasoning above.
Well, I understand the semantic point you make, but if you then accept these propositions, first of all, you don't know what sort of people will be looking and reading these decisions to make their decision. One has to assume, therefore, they'll have to be reasonable people for those purposes. And then if you accept that members of the British public in general, when you're referring to them, are reasonable people, then you can see that accordingly follows.
Well, no, I don't think that's right, because the problem is not just the focus on the British people. The British people might have a different attitude to staying illegally to your average illegal entrant. So that is a wrong focus. But the second and separate point is that the focus is all on the incidental details of this particular person's life. Whereas, in fact, the message that this case sends, and it will be taken by others, is not limited to his particular life. It's 20 years of unlawful residence is an important yardstick.
Well, is that correct? Because what you dismiss as incidental details is prefaced with their statement that a dispassionate member of the public, let's put that to one side, would not conclude that the applicant has gained any real benefit from his presence. And then they spell out, for myself, I would not describe those as incidental details. He hasn't forged any family life, lived on the outer margins of society, legally unable to work, periods of street homelessness, addicted to drugs and alcohol. Those all support the premise they are setting out in that first sentence, namely, he hasn't gained any real benefit.
Well, but
that's the force of it.
Yes, but that's not the point. I mean, incidental. I was perhaps not clear enough. I didn't put it right. What I meant was the facts specific to him are not the message that this case will send out. We have, I'll come to it in a moment, a conclusion of the President of the Upper Tribunal that 20 years of unlawful residence is an important yardstick. And that conclusion is likely to be followed in other cases, and that sends out a message generally. 20 years is an important yardstick. And I was going to come on to this later, but I might as well sort of make the point now. Take the situation of someone who has been in the UK unlawfully for 18 years, and suddenly the situation in their country has changed. There's now a possibility of removal where there hadn't been before, and they're asked to provide biographical details. Now, as things stand, leaving aside this decision, if one just looks at the immigration rules, they've got an incentive to comply, because they will think, well, as long as I comply, maybe removal won't happen, and I'll be able to qualify under 276 ADE. But the message of this judgment and the important yardstick finding is they'll think, well, actually, I don't need to comply. I can still get there if I can make 20 years of unlawful residence. I can still get there under Article 8, because the message from the courts is 20 years is an important yardstick even outside the rules.
Is that paragraph 120 that you sort of pick it up from? Or is there any other paragraph you particularly refer to?
There is another paragraph. I'll
142. You're talking about the 20 years?
Yes. 142. I'm very grateful. Yes, it's 142 where they say a period of 20 years is an important yardstick.
Right. So it's 120 and 142, the particular things that you say send out the wrong message.
Yes.
That's a fair summary of them. Thanks.
The period of time the person has spent in this country is a relevant factor.
Yes. The period of time they spent in the country is a relevant factor, absolutely.
So the fact that it's 5 years, 10 years, 15, 20, 25, 30 is relevant.
Yes. But 20 years is not an important yardstick. And that's not, we'll see, there's also a reference to the rationale of 276 ADE. The rationale of 276 ADE is not that 20 years is somehow a sort of critical period for Article 8 purposes. It's 276 ADE has to be understood as part of a scheme to incentivize good behavior.
So what are you criticising? The use of the word important or the use of the word yardstick?
Or both, especially together. It's just not a yardstick at all. A yardstick is means, especially when it's called an important yardstick, that if you can sort of meet 20 years of unlawful residence, well, then you're almost there. You've almost won your Article 8 case. And that's just not right. That's a misunderstanding of what 276 ADE is trying to do. So paragraph 139, this is where the tribunal starts to look at paragraph 276 ADE of the immigration rules. And this is introduced by my learned friend, Mr. Carney. And they rightly recognise that he doesn't meet the suitability requirements. But then in both paragraphs 141 and 142, they misdirect themselves as to the significance of 20 years and what's to take from 276 ADE. So paragraph 141, they say, although leave must be refused by reason of Part 13 of the immigration rules and general unsuitability, we consider Mr. Connick is still entitled to point to the applicant's 20 years continuous life in the United Kingdom as representing a material Article 8 private life factor. And then they expand and clarify that in 142. In approving the rules, Parliament has acknowledged that a period of 20 years spent in the United Kingdom is an important yardstick in determining whether the right to respect for a person's private life. Pausing there, the sort of syntax is broken down, but the sentiment is that it's an important yardstick in determining whether the right to respect for a person's private life should require a grant of leave to remain. And then they mention a consideration which is not a material consideration, the fact that imprisonment is not per se a disqualifying factor because the rules speak of discounting any period of imprisonment. Well, that's all very well. Very short periods of imprisonment might not be a disqualifying factor, but long ones, like AMs, are. So really, they should not have been taking this point into account as somehow mitigating the fact that he's just not suitable. That those words in parentheses, discounting any period of imprisonment, are, for the purposes of calculating time, ex hypothesi in a situation where someone has never had a long period of imprisonment, because otherwise they would have been disqualified as unsuitable.
You accept that 20 years continuous life in the United Kingdom is a material Article 8 private life factor?
I accept that the length of life in the United Kingdom is a material Article 8 private life factor. What I don't accept is that there is some special significance in 20 years, or that is a factor that, all else being equal, is likely to mean you have an Article 8 right to remain or have your status regularised.
Well, so is your submission in effect that the upper tribunal gave too much weight in this case to 20 years life in the UK?
Well, that's certainly part of the submission, one way of putting it. They did give too much weight to it, but why did they give too much weight to it? Because they misdirected themselves as to the rationale of 276 ADE.
And just for my note, where do you say they did that?
Well, there comes, when we come on to the conclusion at 148, there's a reference to the overall rationale of paragraph 276 ADE.
Thank you.
That's the third line of paragraph 148. It very much ties together with what they're saying here at 142 and the yardstick comment. In fact, Parliament has never accepted that 20 years of unlawful residence is an important yardstick in Article 8 claims. On the contrary, Section 117B4A, the 2002 Act, is Parliament giving unqualified guidance that little weight to private life in the UK established when a person is here unlawfully should be given, no matter how long. And 276 ADE is part of a carefully balanced incentivisation policy, which is more favourable than Article 8 requires. The 20 years route to leave to remain is the reward that unlawful entrants get if they don't commit serious crimes and if they comply with requests for information, etc. And the effect of this judgment, and any ones that may follow it, is to take away that incentive or diminish it. Because someone who's been in the UK unlawfully for a long period of time will think, I don't need to go through 27680E. My 20 years that I'm going to reach of unlawful residence will be enough. Applying this precedent to get me leave to remain outside the rules. Paragraph 143 looks something like a sort of near-miss principle that they say we do not have details of the actual time served in prison, but assuming he served half the sentences, he would be still have accrued 20 years or be very close to doing so. In fact, properly analysed, we'll say that it's not a near-miss case at all. He's miles away from 27680E. But if we were wrong about that, then this would be a sort of near-miss approach.
Sorry, which paragraph?
Paragraph 143.
Right, okay, thank you. That's the one you rely on as a near-miss bit?
Yes.
Yeah. Thanks.
Paragraph 144. They look at the public interest, but they focus entirely in this paragraph on the facts of AM's life and his present unstable and fragile existence. What they don't focus on here at all in this paragraph is the wider picture of the effect on others. They also get these considerations yes, so that's a focus on him, not on deterrence. We then move on to paragraph 147. And here there is reference. The tribunal say they've taken into account the considerations mentioned in section 117B of the Act. But nowhere do they engage with those considerations. Nowhere do they spell out, we accept that we should be giving little weight to his private life, but ...
Yeah, this was the one that I was right. So, I mean, the complaint that they didn't take into account 117B, I mean, they've expressly confronted it there.
They have said they've taken into account. I accept that, and
well, I appreciate your client might have given it a different weight, but we're not here, as it were, just to do the process again. We're here for legal errors.
Yes, of course. But the point and purpose of 117B4A is that there's a mandatory consideration in a case like this where the result is seemingly completely inconsistent with that mandatory consideration. More needs to be done than saying simply we've taken them into account. There has to be an analysis, a reasoning for why the case is successful, notwithstanding little weight is to be given to the private life.
What do you? They use the words which affords little weight to his private life. What are they? What's the upper tribunal referring to there?
Well, this part is also wrong because they talk about him having precarious immigration leave. He didn't ever have leave. temporary admission is not a form of leave.
That's getting rather textual,
Yes.
speaking for myself. The words little weight to private life is a direct quote or use of the words in 117B4A.
Well, it's a reference to 117B5, but I take the point that, yes,
B5.
they've used the word little weight, yes.
Well, B4A says little weight should be given to a private life that is established by a person where the person is in the United Kingdom lawfully.
Unlawfully, yes.
So,
And then there's 5, which is about when you have a precarious
yes,
leave.
but
Yes.
I mean, okay, you say that that paragraph doesn't properly address 117B4A.
Yes.
And shows what they didn't realise that little weight is given to or should be given to unlawful presence, or what?
Well, they don't. This, coupled with the failure to reflect Article 8 principles, which I'll come on to in our ground 1, demonstrates a legal error in the conclusion that they did. They didn't. What one should do is look at 117B4A and the relevant principles from the Article 8 case law. I accept that they've come close because they've looked at 117B5, which has similar provisions. In fact, they're still looking at the wrong thing because he's never had leave, precarious or otherwise. And they haven't looked at the Article 8 principles, which we'll come to.
Well, I mean, are you being fair there to the tribunal below? Because if you look at the third line, precarious immigration leave through temporary admission. Now, you're quite right to say that temporary admission isn't formally leave. But if you've actually said precarious immigration leave through temporary admission, and you are the president of the upper tribunal, there can be no doubt that you understand what you're talking about.
Well, that may be right. I certainly don't sort of. If the only problem in this judgment were paragraph 147, I wouldn't be here. I simply wanted to point out that there hasn't been a proper grappling with a proper subsection, but I take the point that although there is nonetheless a reference to 117B, there is nonetheless a reference to little weight. So really the errors that there are in 147 are not the critical ones.
Well, I mean, that's why I was surprised about the emphasis on 117B, because, I mean, they have dealt with it. I understand you say unsatisfactorily, that may or may not cross into a legal error, but they have dealt with it.
Well, they have dealt with it, but what they haven't done is they haven't sort of put it together, if you like, with 276 ADE and figured out the correct rationale of paragraph 276 ADE, which takes me to paragraph 148. Here they sort of summarize effectively the key factors in the case, the key considerations that in their view mean that the balance is in favor of a grant of leave. And if you go through all of paragraph 148, you don't see any mention of the critical fact that AM is himself responsible for his own state of limbo. That key factor just doesn't appear in their kind of summary of the main things they've taken into account. Instead, there's no mention of him being in the UK unlawfully the whole time. Instead, what we see is the suggestion that taking the applicant out of limbo would not materially damage the principle of deterrence inherent in the statutory scheme. Well, we say that's an irrational and unreasoned conclusion because it would, because of this finding of yardstick and so on. Then the next point, over regards to the overall rationale of paragraph 276 AD, lead us to conclude that whilst not extinguished, the public interest in effective immigration control is weakened to the point where it's capable of being outweighed by the compelling circumstances. So they see the overall rationale of paragraph 276 ADE as pointing in AM's favour, weakening the public interest in refusing him leave to remain. In fact, if they understood that rationale properly, the incentivization purpose, they would realize that the rationale points the other way. It points against a grant of leave in this case. And that is a key misdirection that certainly may have, probably did, affect their conclusion on the overall balance. And then paragraph 149, they say that balancing all relevant factors, the case is exceptional in the true sense of the word. Anyone reading the applicant's history cannot reasonably regard our conclusion as any green light for others to attempt to withhold material relevant to the establishment of their true identity. Or pausing there, we don't accept that. I mean, green light may not be quite the right phrase, but it certainly weakens the incentivization effect of 276 ADE, which is effectively be compliant and then in 20 years you can get leave. Now there's a case suggesting even if you're not compliant after 20 years, you can probably get leave. So properly understood, we say that the balance points the other way. There's an assumption here in the last sentence of paragraph 149 that there be no commensurate benefit to the public interest in not granting leave. And we say there would be a benefit to the public interest, which hasn't been ever addressed or properly understood by the tribunal, namely the benefit of upholding the line drawn by 117B 4A and 276 ADE, the line that says be compliant and you can get leave to remain after 20 years, don't be compliant and you're going to struggle even after a long time, even after 20 years. So I don't need to go through the rest of the judgment which deals with statelessness. I can then just turn to the fourth section of my submissions, which is the grounds. And as I said, I think I've covered much of this going through the...
Just before you leave that,
yes.
And as you put so much emphasis on paragraph 148, can I just check where they refer to the very compelling circumstances of the applicant's Article 8 case? That must be a sort of a silent reference to 117C. Do you consider that right or not?
Yes.
That's how I'd read it, but I just wanted to check that.
I think that's right, yes. Or the immigration rules which reflect 117C.
Yeah, well, they're the same wording, yeah.
Yes.
Yeah. Okay, thank you. Sorry to interrupt.
So if I then turn to our skeleton argument and make our submissions on the grounds by reference to that, so our submissions on ground one begin on page 49. And you can see at the top of page 49, paragraph 40, the two strands of our argument under ground one. First, we say that on any view, this was not an Article 8 interference case. Because of AM's unlawful status, it could only be a positive obligation case. And the second point is that the right to respect for private life does not impose a positive obligation to grant leave to remain to someone who has no family life in the UK and who has only developed a private life in the UK by their own deliberate refusal to cooperate with removal. So paragraphs 41 and following make this first point. The Strasbourg case law draws a distinction between the immigrants who've been given a right to reside and those who haven't, and those who are unlawfully in a member state. For them, even removal is not an interference with their Article 8 rights. Article 8 can only be engaged where there's a positive obligation to grant residence. There are a couple of authorities that we've referred to make that point. The first is Jeunesse.
Sorry, can I just make sure I've got your submission correctly? You're saying that the removal, just to talk UK for the moment, of anyone who's never had a legal right to remain only infringes Article 8 if they've had some positive right to residence.
No, that's not what I'm saying. Sorry, I haven't been clear.
Because, I mean, the vast majority of the cases that come to the High Court, Court of Appeal, etc., upper tribunal, concern situations where people have never had rights but have then got partners, children, etc., etc.
Yes.
And one looks at it in terms of what is their private life in the UK, albeit illegally established, and is there an interference with it? Whereas your paragraph 41 seems to suggest that's wrong.
Well, it is wrong if it's a case involving someone who's never been settled in the UK. In fact, most of the deportation appeals are concerned with people who have been settled in the UK, but are then made subject to deportation action. In cases where they've never had residence in the UK, you should be looked at as a positive obligation case. Now, that doesn't mean that Article 8 is not relevant at all. And to some extent, I shouldn't spend too long on this because to some extent it's a matter of form more than substance.
But if it is a legal error that we then have to pick up and identify, it's one that's being made daily when people are looking in their rooms on permissions to appeal, etc., etc., or applications to apply for judicial review. You say that they have to analyse it in terms of, well, is there a positive obligation to right to residence? Otherwise, Article 8 is not engaged at all. Is there any UK authority for that?
Yes, FWF. I've 41 and 42. I've cited the leading Grand Chamber judgment on this and the Court of Appeal judgment that confirms it. So, if perhaps otherwise, I think I do need to go to Jeunesse. It's tab 28 of the authorities bundle. You can see from the head note there that this was a case that really turned on family life. Ms. Jeunesse had a partner who lived in the Netherlands and had Dutch nationality, and they had Dutch children together. She initially came on a visitor's visa and overstayed. Now, the key paragraphs, you go to paragraph 105. I'll just pause to let you read paragraph 105. This is how the Strasbourg case law distinguishes between positive obligations and negative obligations in the Article 8 context.
that doesn't match your paragraph 40, which is any case concerning an illegal entrant, because this entrant into this case in Jeunesse was in fact legal.
Well, no, only very briefly. She was had a visitor's visa, then she was illegal after that.
Yeah.
But
if one looks at your paragraph 40 proposition, you're saying cases concerning whether an illegal entrant. So it's an illegal entrant and anyone who's been there lawfully for a little bit.
I should have put it whether it's someone who doesn't have legal residence.
Anyone who doesn't have legal residence. And for that purpose, do you mean to say that temporary admission and immigration bail are not legal residence?
Correct.
And is that picked up in the European case law? Because they won't necessarily have understood that when you say temporary admission, people will assume that's legal.
No, but there is a Supreme Court decision of ST Eritrea that temporary admission is not the same thing as being lawfully in the UK.
Well, of course it's not. I will understand that, but I'm just trying to drill down to see whether or not there is this binary approach in the authorities that you're contending for, and whether or not that's part of our domestic law. Because we have measured regard to the European Court of Human Rights. We're not slavishly following what they say.
I understand. I can't recall off the top of my head whether there's a Strasbourg authority that grapples with the specific meaning of temporary admission. But what I can say is that this case law, it's distinguishing here, paragraph 105, between settled migrants and those others who are seeking regularization. On any view, someone who has only temporary admission is not a settled migrant.
Well, all they're saying is that the legal and factual situation of a settled migrant and that of an alien seeking admission to a host country are not the same.
Yes, but what they also say is, halfway through the paragraph, rather the question to be examined in the present case is whether, having regard to the circumstances as a whole, the Netherlands authorities were under a duty pursuant to Article 8 to grant her a residence permit.
Right, that was the question in that case, because that's what was being sought by the applicant claimant. She was seeking the grant of a residence permit. So that was why that was the question in that case. And as they go on to point out, that overlaps family law and immigration. And so they phrase it as an allegation of failure to comply with the positive obligation being to grant her a residence permit.
Yes.
It's not saying the case is divided between positive and obligations interference. It's just saying in that case we're dealing with what is asserted to be a positive obligation pursuant to Article 8 to grant a residence permit. Isn't that it?
No, I'm not sure that both sides were saying it should be seen as a positive obligation case. This is the Grand Chamber setting out that this kind of case is a positive obligation case.
Well,
and that's certainly how it's been taken. I mean, there are. Hesham Ali talks about the distinction that makes the point that ultimately it may not make a difference when you're looking at both. There's a fair balance that needs to be struck.
Because it depends on what the issue is, as to whether you're saying what is happening is unlawful interference with an Article 8 right, or whether you're saying Article 8 gives me a specific right to something. So it all depends on what the issue is.
Well, what it depends on, in my understanding of the case law, is whether you're talking about the immigration rights of settled migrants as opposed to the immigration rights of those who are not settled.
Well, that will be a relevant factor.
But that's what determines whether it's a positive obligation case or a negative obligation case.
May I just say, before we leave this, Is paragraph 106 also relevant?
Yes, absolutely, it is, and that makes the point that ultimately it doesn't necessarily make much difference. The boundaries don't lend themselves to precise definition, and either way, there's a fair balance that needs to be struck.
But that was slightly making the point I was making to you. If you're saying that it's a legal error not to analyse it in terms of positive obligation, then that's certainly not supported by 106, which says it doesn't really matter.
Well, as I said before, I think it is a question of form more than substance, and I didn't want to spend too long on it for that reason, but it does affect how the declaration should be made if you're against me, and it also does set out what sort of strand of the Strasbourg case law one should be looking at.
What I was going to, deportation is an interference because you're doing something to somebody's private or family life which can be properly classified as an interference. When you're seeking the grant of a residence permit, you can't classify that as an interference. So it's whether, having regard to the Article 8 balance, that is the appropriate interpretation of the rights granted in the specific case.
Well,
is it any more than that?
Perhaps not, but even if that's right, and we're looking at the context of this case, what we are talking about is someone who is saying, you should regularize my status. You are under a positive obligation to regularize my status. Yes. This case is not about, you can't deport me. And so whether one looks at it in terms of whether it's about settled migrants or whether it's about positive action of removing someone, this is clearly a positive obligation case. I accept that, but in even being a positive obligation case, it's about fair balance.
There is an element of negative obligation here because his status currently at the moment prevents him from working, which he was doing after his release from prison.
Well, again, I'm conscious of the fact that I'm running out of time, and I don't want to spend too long on my. This is my fault. But I'd rather simply accept that it's a matter of form more than substance, and move on to the substance of the case law on how you strike that balance. In my submission, it is properly a positive obligation, even if one's talking about working, because what one's saying is that the state is under a positive obligation to allow this person to work, which is a typical consequence of regularizing their status.
Just before you do, you've referred to FWF,
yes,
paragraph 143.
Yes.
Is that the only paragraph that you would... I see 143 and 144 are sidelined.
Yes, those are the key ones on the distinction between positive and negative.
Right, thank you.
Can I go back to the second limb of ground one in my skeleton argument, which is page 50 of the core bundle? And what we submit there is that there is no authority, either in the domestic courts or in Strasbourg, which even begins to suggest that the right to respect for private, as opposed to family life, imposes a positive obligation on a member state, put another way, a duty on a member state to grant a residence permit to someone who's lived for a long time in that state as a result of refusing to provide the cooperation necessary for removal. And the only Strasbourg authority which comes anywhere near these facts, in fact points the other way, declared manifestly ill-founded, and that's Dragan. As it was a decision, the official version's only in French. And we've got a Google translation and an information label. What I'd rather do is take you to a later judgment which confirms and explains the principle to be taken from Dragan, and that is Ramadan behind tab 29. Now, the facts of Ramadan are complex, and it's not necessary to go through all of them. But in essence, Mr. Ramadan was Egyptian. He entered Malta on a visa and overstayed and married a Maltese citizen. He applied for Maltese citizenship and claimed he'd renounced his Egyptian citizenship. And that led to paragraph 92 of the Strasbourg Court's reasoning. Can I take you to that? It's page 840. Can I just ask you to read paragraph 92, and I'll make submissions on the last sentence, which, as you'll see, refers to Dragan in the footnote.
So, what do you ask us to take from that?
I ask you to take from the last sentence in particular the principle that states don't have an obligation to regularize the status of those who have made removal impossible through their own voluntary actions.
Well, what the last sentence says, and I think what Dragan also says, is that a state does not mean in principle that another state has the obligation to regularize simply because the foreigner has renounced his or her nationality. In principle.
Yes.
Does it go any further than that?
Well, no, it doesn't. It says that as a general principle, if someone, I mean, it's obviously talking about renunciation of nationality, but that is no different in practice to voluntarily making removal impossible or in other ways. Right? For example, not revealing the information about your true identity. And the principle is that if you're doing that, that can't impose a duty on the state to effectively then say, well, you've won, we'll regularize your status. Now, of course, in cases involving family life, then there may be other factors that require a regularization of status if it impacts on children and so on. But in principle, if one's talking about a private life case, then and someone is making it removal impossible through their own voluntary action, that is not a situation in which the state needs to effectively say, well, you win, we'll regularize your status.
Sorry, if you look at the head note, paragraph 9, what were the facts of this case?
So
it was about the decision of the Maltese authorities to deprive the applicant of his Maltese citizenship.
yes.
He wasn't threatened with this expulsion, able to continue. didn't apply for a work or residence permit, which would have made him eligible for citizenship. The Convention did not guarantee the right to a particular type of residence permit. If a permit holder was able to reside in the territory and exercise freely the right to respect his private life, the granting such a permit constitutes a sufficient measure to meet the requirements of Article 8.
I entirely accept that the facts and issues of Ramadan were different. They, as you say, they're about whether he should be granted Maltese citizenship. I only took it to you as a sort of neat way of encapsulating the principle in Dragan without having to resort to either the French or an information note.
Right. Thank you.
My lords and my lady, it's shortly before 1. I was going to take you to Mendizabal to try and finish off ground 1, but if you prefer, we could...
Let's do that.
So Mendizabal is at tab 32. You'll note if you look at the head note, page 907, this is a decision of 2010 arising out of an application made in 1999. This was a Spanish national, you can see from the first paragraph, who'd been lawfully resident in France since 1975. So not just 14 years. And not unlawful residence. Lawful residence since 1975, so some 35 years by the time of the Strasbourg judgment, 24 years by the time of her application. She was a Spanish national, which is relevant in other ways. What the case really turned on is the EU law. And the fact you can see that at paragraph 67 of the judgment.
Very minor point. Was the decision actually January 2006? It's only reported.
Yes, I apologise. I think you must be right about that, my lord. It seems,
it's just not reported until 2010, or not reported in this country until 2010.
I think that must be right.
Yes.
Paragraph 67 identifies the key issue. Paragraph 67, the court considers how this case requires a different approach. And that's different to what they've been talking about in paragraph 66, about how Article 8 is not concerned with the right to a particular type of residence permit, permanent, temporary, or otherwise. But they say it's a different approach in this case. In fact, the key issue is the status of the applicant as a community national, who at least, counting from the end of the transitional period for Spanish nationals, 1992, was directly entitled under community law to reside in France and be issued with a residence permit for a national of a member state of the EEC valid for 5 years. So that is that key consideration which leads them to think that paragraph 72, they describe that case as an interference, and they stress the fact she'd been lawfully resident in France for over 14 years. And so they say the failure to issue her with a sort of permanent residence permit is an interference. And then they say at paragraph 79 that this wasn't in accordance with the law, and it wasn't in accordance with the EU law as well as the French law. As I hope that makes clear.
So there they're saying the failure to give a residence permit was an interference.
To give a permanent residence permit. She had.
I'm sorry, I'm accentuating or intended to accentuate the word interference.
Yes.
So it looks as though it's slightly movable.
Well, I accept that the boundaries are not clear, as they've said a few times. There can be grey areas. In my submission, in our case, where we're talking about someone who's never had any form of lawful status, and they're asking for it to be regularised. That is clearly on the positive interference side of the line, but I've already
Right.
taken up
No,
too much time.
Don't worry. That was me. I should have let it go. Especially given the time. Thank you.
So, my lords, I suggest I pause there. I hope I can finish my submissions in 30 minutes. It might help for me to do so if I give you a sort of speaking note I've been speaking to, if that would be helpful. I know a talk by Lord Justice Irwin on advocacy said that there's a special place in hell for people who hand up speaking notes. So I don't want to reserve a place in hell for myself by doing so.
Do you want it or not?
Well, I mean, if you think it will enable you to finish, and I think his speech was directed at those who handed it up at the beginning of submissions rather than to shorten the submissions after the lunch break.
Are there things in it that you haven't? When you're giving us the whole lot,
What I intend to do is to sort of make a few.
so all if you're giving us something, either you need to ensure that they've all featured in your oral submissions, and/or you need to give a copy to Ms. Weston.
I certainly intend to give a copy to Ms. Weston and those behind her. I also intend it to be limited to things I've said orally.
Okay.
I'll work over the short adjournment to do that. What I can't promise to do in the short adjournment is necessarily answer all the questions my lords and my lady
Don't
have
worry.
put to me.
Okay.
But
Yes.
we'll endeavour to do that before tomorrow.
Yes. Thank you. So we'll start again at 2:00.
Court rise.